Good day, everyone. I am Daisy Munsami, a civil legal practitioner of Legal Aid South Africa, and I'm based at the Pietermaritzburg local office. I deal predominantly with family law matters and administration of deceased estates. I've been tasked to discuss the relationship between Legal Aid South Africa and the Master's Office, and more especially my interaction with minor children who are in fact the beneficiaries in these deceased estates. The Department of Justice and Constitutional Development had to develop and implement an unified system of supervision of the administration of deceased estates that delivers the same quality service to all South Africans without distinguishing on the basis of race, gender, age, or birth. This basically means only the Master of the High Court will supervise the administration of deceased estates. Over the years, the Master's Office used to administer and appoint their own legal representatives. The problem that the Master faced was that these representatives or guardians were not using the monies for the best interest of the minors. So therefore, the Master decided to change. Now, the primary function of the Master is to regulate the administration of deceased estates. The duty of the Master is to ensure that the legal and financial interests of those affected in the administration of an estate are taken care of in a compassionate manner. That at all times to bring about transparency and consistency in which appointments of administrators of estates are made, and more especially to eliminate all forms of corruption. In the year 2010, the Chief Master, Person, and Legal Aid South Africa signed a cooperation agreement whereby all matters pertaining to deceased estates where minors who are beneficiaries in this estate were entitled to legal representation. Legal Aid South Africa thereafter appointed qualified legal practitioners who were trained to handle the administration of deceased estates. This resulted in the Master's Office referring matters to Legal Aid South Africa and their respective local offices to assist with children in estate matters. Legal aid practitioners exercise the highest ethical standards when dealing with children estate matters because of the nature of the matter. Further, no employee of Legal Aid South Africa should derive any financial benefit from the estate under administration by Legal Aid South Africa. And with this cooperation agreement in place, Master's Office and Legal Aid South Africa have one primary objective, and that is the financial legal interests of children that need to be protected at all times. There are two types of deceased estates that you should be aware of, the Section 18.3 estate and the full estate. Now, the crucial question is, which is which, and how does it impact on the administration process? The administration of an estate is determined by its gross value. So if you left an estate with an asset value exceeding 250,000, it is a full estate. However, the law has changed and the value in terms of Section 18.3 of the Administration of Deceased Act was changed from 125,000 to 250,000. So any estate that is below 250,000, a letter of authority will be issued. And anything more than 250,000, a letter of executorship is issued. Now, legal aid practitioners deal mostly with the Section 18.3 estates, whereby we have letters of authority being issued. Now, Section 18.3 is generally considered to be simpler and less costly to administer than a full estate due to the lesser value of the estate, which simply means there's no advertisements, there's no need to submit any liquidation and distribution account. the executor's fee will be levied in terms of the Estate Administration Act. Now, the question is, when somebody dies, what happens? Normally, family members will approach the master's office and they have to report the estate. And it's also a time when people take this in a very different light. Some, they get very agitated. So they expect results. They expect monies immediately. So this is the advice we normally will tell our clients when they come to the office. You firstly got to report an estate to the master or at a service point. We cannot report the matter. Our local officers in the rural areas cannot report this matter. It has to come from a family member of the deceased. So the estate of a deceased person must be reported to the master of the High Court within 14 days of the date of death. The reporting documents will differ slightly depending on the value of the estate and the type of appointment required. That is, if you want a letter of authority or if you want a letter of executorship, depending on the value. Now, if the value of the estate is less than 250,000, the Master of the High Court issues the letter of authority in terms of Section 18.3 of the Administrations Act 66 of 1965. In these cases, legal aid will assist, provided, and I stress on it, provided there is a minor that is going to become a beneficiary in this estate. If the estate exceeds 250,000, a letter of executorship must be issued as prescribed by the Act. Letters of authority entitle the nominated representative to administer the estate without following the full procedure as set out by the Administration of Estates Act. Now, when you're reporting these matters, the following documents need to be completed at the master's office. You have to complete a death notice. You have to provide the master with a certified or the original death certificate, original marriage certificate if the parties were married, proof of religious marriage, for example, if you're Muslim or Hindu, declaration of subsisting marriages, all wills or documents purporting to be such. A next of kin affidavit has to be completed. An inventory whereby your assets and liabilities will be completed by the master. The list of creditors, nominations by the heirs, acceptance of master's directions. And it should be noted, all of the mentioned documents has to be handed to the master's office. Fax documents are unacceptable. All these documents will be lodged with the master and they will examine and they will be accepted or rejected. When it comes to Legal Aid South Africa, once all these documents have been completed at the master's office, the master will now give the client a referral form. This was in terms of the co-op agreement between the master's office and Legal Aid South Africa in 2010. Together with this referral form comes a next of kin affidavit, a death notice. Our paralegals will take the initial instructions, and once these instructions are taken, the file is then handed over to the legal practitioner, who will then lodge his acceptance and undertaking as the executor of this estate. But at all times, we got to remember, legal aid only deals with matters where there's a minor child, and that minor child is going to benefit from this estate. All children are entitled to inherit. It makes no difference whether they were born from a civil marriage, a customary marriage, were adopted, or born out of wedlock. An example of a customary adoption is explained as follows in the decision of Motsepa versus Kosa, Loosely translated, it means to take the child born of another man into your marriage with its mother for all interests and purposes is equal to the customary adoption of a child. So this basically means that whether a child was born in marriage or out of marriage, the child is still entitled to inherit what is due to him or her. There's a question that we always been asked. What happens if there is one minor child but 3 majors? In a case like this, we will still have to administer this estate. The process goes as the 3 majors will receive their payment directly from Legal Aid Trust Account, which is based in Johannesburg. They become vendors, and then the monies are deposited directly into their bank accounts. However, the minor's share will be then deposited into the guardian's fund, and that child will receive payment as per the guardian's memorandum, and they will receive biannual payments until they reach the age of 18. Now, Legal Aid South Africa has given special attention to matters pertaining to children. Legal Aid and all local offices have created and maintained relationships with government departments such as Social Development, Guardians Fund, Master of the High Court, local municipality, Deeds Office, and all NGOs that deal with children's matters. The next step when it comes to administration of deceased estates is clients generally will question us as to what happens when we receive the letter of authority and whether or not they will get a copy of. I will normally make a copy of the letter of authority, have it certified, and you can either post it to your client or your client can come to the office and pick it up. Once we're in receipt of the letter of authority, we now know what assets are in this estate. So there will normally be banks, various banks, investors, institutions. We now have to write to these respective banks, investors, and institutions, requesting them to transfer the monies into Legal Aid Trust Account. Once the monies are transferred into Legal Aid Trust Account, we then obtain deposit slips from the bank's investors so that we can submit these deposit slips to the finance department in order for finance to reconcile with the banks and the investors' deposits. All estate monies in connection with an administration of an estate should be processed through Legal Aid Trust Account. What has transpired now is that Legal Aid South Africa has a web page whereby all documents have to be uploaded on the system, and all these documents have to be signed and countersigned by the head of office and the civil legal practitioners of each local office. Therefore, when clients come in and apply for legal aid, we always stress that together with the referral letter, the next of kin affidavit, and the death notice has to be given to us, because without those 2 documents, we are unable to upload the web page, and therefore monies cannot be processed and monies will then not be transferred into the Guardian's Fund. The next question is, and clients always question us about, is what is the Guardian's Fund? And they tend to get confused between the Master's Office, the deceased estates, and Guardian's Fund. So we need to explain to them, when you're reporting your matter, you will go to the deceased estate section. Once the monies are in the deceased section, and once we have finalized the transfer of funds from the respective banks into Legal Aid Trust Account, the monies will then go into the Guardian's Fund. And it's also a process because we then have to apply for the Guardian's Fund number. Once we're in receipt of this number, then only can monies be transferred. Now, the Guardian's Fund falls under the administration of the Master of High Court. It is a fund that is created to hold and administer funds that are paid to the master on behalf of various persons, known or unknown, for example, minors or persons incapable of managing their own affairs, or missing or absent persons. Once monies are transferred from legal aid trust account into the guardian's fund, our mandate terminates. The guardian will now deal directly with the master's office. It should be noted at all given times, none of the legal practitioners or any interested parties in Legal Aid South Africa actually deal with the physical exchange of monies. All monies are exchanged electronically, and it's generally done from the banks straight into legal aid trust account. Once this is done, we inform the client to contact the guardian's fund. The guardian's fund will then make biannual payments to the guardian for the benefit of the child until the child reaches 18. With regards to the adults or the majors, their share of monies will be deposited into their accounts. Another question that we've been asked is regarding the timeline for winding up of a deceased estate. The process and timeline for winding up a deceased estate could be overwhelming for the deceased family, and in some instances, beneficiaries of the estate do not always understand the administration process associated with the deceased estate. The first step is consult with the deceased family, obtain all the relevant documents to register the estate, and this must be done within 12 months after the death of the deceased. One of our delays is that the banks and institutions do take fairly long time to actually give us the monies. One can safely state that in the past 10 years, Legal Aid South Africa, the Master's Office, has built an excellent working relationship. There's ultimate compliance and respect when handling estate matters, because our primary objective at all times are the financial and the legal interests that are in the best interest of our children. If you have any further questions, kindly contact one of our local officers within your jurisdiction, or call the toll-free Legal Aid Advice line on 0800 110 110, or you may send a please call me to 079 835 7179. Thank you.